So thank you all for joining me today and welcome to today's presentation, Understanding Family Law. Just to introduce myself, I'm an associate solicitor with Michael Lynch Family Lawyers. I've worked and practiced exclusively in family law in both Melbourne and Brisbane for almost 12 years now. For those of you who are not familiar with our firm, Michael Lynch Family Lawyers, we're a specialist family law firm and in 2016 celebrated our 20-year anniversary of practice. We have 9 solicitors, 5 of them are accredited specialists in family law, and we've recently appointed 2 of our accredited specialist directors of the firm. We provide advice and assistance to clients on a wide range of family law matters and assist with negotiation, mediation, and court representation if required. Okay, so in terms of the presentation today, the aim is to give you an overview of the frequently used terms in family law and then to explain each of these in turn. And I'd also like to send you away from today with a clearer picture of the principles and processes involved in family law as they relate to parenting specifically. So the issues we'll talk through today are the types of relationships for the purposes of the Family Law Act, being de facto and married relationships, separation and divorce, principles and processes as they relate to parenting arrangements, the resolution processes that parents can use to reach an agreement and document those agreements, as well as discussing the court process as it applies to parenting and how the court process may include you as counsellors. And I'll conclude by giving you a brief overview of family and domestic violence laws and recent changes to those laws in Queensland. The main applicable law in family law, as many of you are no doubt aware, is the Family Law Act 1975, which is a Commonwealth Act and applies in all states and territories of Australia, except Western Australia. It deals with matters involving divorce, property settlement after marriage breakdown or de facto relationship breakdown, and issues relating to parenting arrangements after separation. So when I talk about the Act in this webinar, I'll be talking about the Family Law Act. There have been many amendments to the Act since its enactment, and the most recent significant amendments are in 2012 and relate to the family violence provisions of the Act. The courts which exercise jurisdiction in relation to the Act are predominantly the Family Court of Australia and the Federal Circuit Court of Australia, which was previously the Federal Magistrates Court of Australia. Magistrates' courts in each state, except WA, are also able to exercise family law jurisdiction under the Act in a limited capacity, such as approving consent orders made by agreement between the parties which relate to parenting and/or property. So for the purposes of the Act, the 2 most relevant relationships are marriages and de facto relationships, and I'll discuss both of these in turn. Just briefly though, de facto relationships are relationships which have a genuine domestic basis and one of 4 other factors present, and I'll discuss these further shortly. For the purposes of today's webinar, I'll be focusing on de facto relationships as they relate to parenting matters, not property. As and from 9 December 2017, sex and gender no longer affects the right to marry under Australian law. The definition of marriage in Australia has now been amended to the union of 2 people to the exclusion of all others voluntarily entered into for life, as defined in the amended Section 5(1) of the Marriage Act 1961. While discussing marriage, I also wanted to provide some clarity regarding the term nullity. A declaration of nullity is a finding by the Family Court of Australia that there was no legal marriage between the parties. A decree of nullity is an order which has the effect of saying that there is no legal marriage between the parties, even though a marriage ceremony may have taken place. The Family Court of Australia may declare a marriage invalid, i.e. as if it's never occurred, on the following grounds. At the time the parties were married, one or both of them was married to someone else. The parties in a prohibited relationship are in a prohibited relationship pursuant to Section 23(b)(1) lowercase b of the Marriage Act, such as a brother and sister, but cousins may marry. The parties did not comply with the laws in relation to the marriage in the place they were married. One or both of the parties were underage and did not have the necessary approvals, i.e. the consent of their parents. Either of the parties did not give their real consent to the marriage because consent was obtained by duress or fraud, one party was mistaken as to the identity of who they were marrying or the nature of the ceremony, or one party was mentally incapable of understanding the nature and effect of the marriage ceremony. And just by way of example, I'll discuss quickly consent obtained by fraud. So when considering whether the parties did not give consent because it was obtained by fraud, the court applies a very limited scope to the term fraud as it appears in the Marriage Act. In Marquis and Marquis, a 2012 case, the husband sought a declaration of nullity on the grounds that he was induced to marry by fraudulent declarations of love. He claimed that shortly after the wedding, the wife indicated that her real motive for the marriage was to gain permanent residency in Australia. The application was dismissed on the basis that the fraud did not go to the party or the nature of the ceremony. Rather, it went to the individual motives which the wife may have had for marrying. The fraud must be perpetrated on the other party, not some third party, and in that case, the third party was the Australian government. A total of 76 applications for final orders for validity or nullity of marriage were filed in the Family Court of Australia between 1 July 2009 and 30 June 2012. From these applications, 33 decrees were granted. Of the remaining 43 applications, 11 were discontinued, 22 dismissed, 2 resolved by agreement, and 8 withdrawn. A nullity differs to divorce as a nullity order declares that the marriage never took place, whereas you can only seek a divorce order where the marriage is valid. The Family Court will only grant a decree of nullity in extremely limited circumstances, and this is rarely a viable alternative to divorce. The law on nullity has arguably become harder, and there remain serious limitations on the availability and use of this remedy. I will discuss divorce shortly, but for now, let's move on to de facto relationships. De facto relationships are a little more complex to define. One of the difficulties in defining a de facto relationship is that every de facto relationship is different. A person is in a de facto relationship with another person if the persons are not legally married to each other, and the persons are not related by family, and having regard to all the circumstances of their relationship, they have a relationship as a couple living together on a genuine domestic basis. A de facto relationship can exist even if one of the parties is legally married to someone else or is in another de facto relationship. Now, when determining what is on a genuine domestic basis, the court considers the following: the duration of the relationship, the nature and extent of their common residence, whether a sexual relationship exists, the degree of financial dependence or interdependence, the ownership, use and acquisition of property, the degree of mutual commitment to a shared life, such as having joint investments and holidaying together, the care and support of children, and the reputation and public aspects of their relationship. That is, are they known in their peer groups as in a committed long-term relationship? I was involved a few years ago in a matter where the parties in a same-sex relationship acknowledged that they had shared a residence on various occasions for a total of more than 6 years between 2005 and 2013. I acted for the party that disputed the existence of a de facto relationship, as my client asserted that the relationship was one of friends with benefits. The court found in favour of my client and declared that a de facto relationship never existed between the parties. There was no evidence of any joint ownership or acquisition of property, nor a mutual commitment to a shared life, nor a public perception of the existence of a de facto relationship between them. The other party contributed little financially to the residence and only lived with my client when he chose to do so for his own benefit and convenience. And I'm happy to give any of you the case reference for that case, as it's a reported decision of the Federal Circuit Court, so please email me following this webinar if you'd like the details. A de facto relationship will be found where the relationship is of a genuine domestic basis, as we've just discussed, and one of 4 gateway criteria are met, and these are the parties have been in a de facto relationship for at least 2 years, or the total periods of the relationship was no less than 2 years, or there is a child of the relationship, or a de facto spouse made substantial contributions and a failure to make an order would result in serious injustice to the applicant, or that the relationship is or was registered under a prescribed law of a state or territory. Now, a couple of interesting cases to demonstrate that defining a de facto relationship is anything but straightforward. In a 2013 case, the applicant asserted a 9-year de facto relationship. The parties had 2 children, but did not live together for any period longer than 7 weeks. The parties disagreed with regard to how they would live together and where. Her Honour found that this ongoing argument demonstrated a mutual commitment to a shared life, and it was held that there was a de facto relationship. In a recent matter, we acted for a client where there was a child of the relationship, and that is, the gateway requirement was met. However, the other party argued that there was no de facto relationship, as they did not live together for a period of more than a few weeks. There was no financial interdependence. There was no mutual commitment to a shared life, and the relationship was nothing more than a sexual attraction for mutual sexual gratification. The court, however, made a declaration that the parties were in a de facto relationship. That is, the relationship was of a genuine domestic basis. And the court based this on the parties undertaking fertility testing, IVF treatments, and obstetrician appointments together. Together, they shared news of the pregnancy with the applicant's family. The respondent ticked the affirmative question regarding him having a spouse on a mortgage application, and the respondent made a witness statement to the Queensland Police stating, "I am in a de facto relationship with the applicant." Whether or not a de facto relationship exists is relevant only in relation to applications for property adjustment matters and not relevant for parenting matters. The relationships that are relevant in parenting matters is the relationship of a person making the application to the child or children. But just for completeness, de facto parties who wish to formally resolve any property matter between them following the breakdown of their relationship can only apply the process and resolution under the Act if they separated after 1 March 2009, and the application, including consent order applications, must be filed within 2 years after separation. There are exemptions, however. If an application is made following this 2-year period, the applicant must seek leave or the permission of the court to do so, which includes explaining the delay and that they or a child of the relationship would suffer hardship if the court did not determine the matter. So moving on to separation, I'm frequently asked, what is the document I need to sign, or what do I need to do to prove I am separated? So to be clear, separation occurs when at least one person in the relationship makes a decision to separate, acts on that decision, and tells the other person. The other person in the relationship does not need to agree. One party can then physically separate, that is, move out, or you can be separated and not physically separated. That is, the relationship is at an end, but you are still living in the same house. So in short, separation is a state of mind of one person in the relationship, and there is no legal requirement for separation. The date of separation only becomes relevant when making an application for divorce, as we'll discuss shortly, and when making an application to the court in relation to de facto property matters. The 1975 Act establishes the principle of no-fault divorce, with 12 months separation, whether under the same roof or not, being sufficient to prove breakdown of marriage. And prior to 1975, some form of wrongdoing by either party had to be proved. Same-sex couples whose marriages are recognised can access Australia's divorce system, regardless of when the marriage was solemnised. The divorces of same-sex couples who divorced overseas before 9 December 2017 are also recognised in Australia. Same-sex couples who divorce overseas on or after 9 December 2017 will have their divorce recognised in Australia in the same circumstances as any other married couple. And the Federal Circuit Court of Australia has jurisdiction to deal with the dissolution of marriage. Once a divorce order is granted by the court, this order only recognises the marriage is dissolved and does not determine issues of financial support, either spousal or child support, property distribution, and the arrangements for the care of the children. So in the next part of this webinar, we'll discuss parenting arrangements following separation. So let's begin by looking at the principles of the Act, so far as they relate to parenting matters. The most important thing to know, and probably many of you do know, is that the child's best interests are the paramount consideration for the court when considering parenting matters. It's also important for, where appropriate, usually both parents to have a high level of meaningful involvement in their children's lives. And certainly that's the aim of the Act. Ideally, parents should try to reach agreement between themselves about parenting arrangements rather than relying on the court processes to determine those for them. Following separation, the two main parenting issues that parents need to reach agreement about or request the court decide are parental responsibility and living arrangements for children. So let's discuss each of these in turn. Parental responsibility is defined in the Act as all rights, powers and duties that parents ordinarily have in relation to their children. That responsibility relates to both decisions about day-to-day issues and major long-term issues. Day-to-day issues are things like what time the children go to bed, who can care for them, and what they eat for lunch, those sort of day-to-day issues. And there's no need for any input from the other parent on those issues. Major long-term issues are defined in the Act as issues that relate to the children's health, education, changes to their name and changes to their living arrangements that make it significantly more difficult for the child to spend time with the other parent. The Act provides that whenever a court makes an order, whether making a determination or approving consent orders agreed to by the parents, which we'll talk about shortly, the court must apply the presumption that it's in the best interest of the child for their parents to have equal shared parental responsibility for them. An order of equal shared parental responsibility means that parents must consult with each other and make a genuine effort to come to a joint decision in relation to major long-term issues, so those being education, health, changes to a child's name, or changes to their geographical living environment. That presumption does not apply if there is family violence, and it can be rebutted if there are other reasons why it's not in the child's best interest for the child's parents to have equal shared parental responsibility. The alternative to equal shared parental responsibility, which is the required position in most cases, is sole parental responsibility. So one parent having the sole power to make all those major long-term decisions, or sometimes one parent will have sole responsibility for particular areas such as the child's health. And day-to-day issues continue to be the sole domain of the parent whose care the child is in at that particular time. So there's no need to consult the other parent about daily inconsequential decisions. The flow-on effect, as detailed in the slide, for a child's living arrangements of how parental responsibility is exercised, is that if parents have equal shared parental responsibility, then the first type of living arrangement that the court must consider is the children living in an equal time arrangement with both parents. However, such an arrangement will only occur if it is in the best interest of the particular child and it is reasonably practicable. If it is not in the child's best interest, nor is it reasonably practicable, then the next arrangement the court must consider is substantial and significant time, and in my experience, this type of arrangement is occurring in the majority of separated families. So what that means is that the children live primarily with one parent and spend time with the other parent, that is, substantial and significant. And in reality, that means time not just on weekends, but also includes time on weekdays, school holidays, and special occasions. The aim being that it allows the children to be involved in the day-to-day life of the other parent and vice versa, the parent being involved in the day-to-day experiences and requirements of the child, like arguing about doing homework and brushing their teeth, as well as being involved in downtime and special occasions. And again, substantial and significant time would only apply if it's in the best interests of the particular child and if it's reasonably practicable. And when I say reasonably practicable, we're essentially talking about, do the parents live close enough to each other so they can both facilitate getting the children to the same school? And do the parents have a level of cooperation between them, which means they can reasonably coordinate if, for example, a child leaves their runners at one parent's home and they need them for school when in the other parent's care, those sort of practical issues. So let's turn to determining best interests of a child. The child's best interests are and should always be the most important consideration for the court and for parents when trying to reach agreement regarding care arrangements. The Act, specifically in section 60(cc), sets out the considerations when determining best interests, and these are primary considerations and additional considerations. The primary considerations are the benefits of a child having a meaningful relationship with both parents, and the need to protect the child from physical or psychological harm and from being exposed to abuse, neglect, or family violence. The Act specifically says that if there is a conflict between these two primary considerations, the need to protect the child from harm takes priority over the benefit of a meaningful relationship with both parents. Section 60cc also sets out 13 additional considerations that the court must take into account when looking at the child's best interests, and includes things like the child's wishes and views, the capacity of each of the parents to provide for the child's care, the extent to which they have been involved in the child's life and taken an interest in the child's life, and their attitudes to the responsibilities of parenthood, etc. So these considerations essentially say that if there is anything specific to the child's circumstances which is relevant to what's in that child's best interest, it should be taken into account by the court when determining the child's best interests. So having looked at the principles of the Act, let's now talk through the resolution processes that parents can use, bearing in mind the principles of the Act, to get to a point where they have orders or an agreement about parental responsibility and living arrangements. The first means of reaching agreement is by direct negotiation between the parents, and obviously that's the ideal outcome. If that doesn't work, then sometimes people will see a solicitor, get some advice, and hopefully the solicitors will assist them to negotiate an agreement. Family Dispute Resolution, or FDR, is a mandated mediation process to assist and encourage parents to come to an agreement in relation to the arrangements for their children. FDR is required by the Act prior to making an application to the court, unless in circumstances of urgency or family violence. And if none of those processes are successful, then as a last resort, one parent may need to consider a court application. If the parents are able to come to an agreement after one of those processes, there are three options in terms of documenting that agreement. The first is to keep the arrangements completely informal, and many families choose to do that if they feel comfortable that those arrangements will be followed and that there is a level of trust between the parents. If the parents want to make the arrangements more formal and reduce the arrangement to writing, then the two options are a parenting plan or consent orders. So a parenting plan is a written agreement that sets out the arrangements for the children. It can be quite detailed in terms of, for example, what happens during school holidays, birthdays, and on special occasions, and can cover things like the extracurricular activities the children might want to do. It can be quite specific depending on the needs of the parents. In order to be valid as a parenting plan, that agreement must be signed and dated by both parties and made free from duress. The benefit of a parenting plan is that it's quite flexible, but the downside is that it's not strictly a legally binding document. And what that means is if a parent breaches a term of a parenting plan, there's no means to enforce the terms on that parent. However, if the matter later goes to court, the court must have regard to the terms of the parenting plan, and usually an explanation as to why someone has departed from the parenting plan would be required. The alternate means of formalising an agreement between the parents is legally binding, and that's consent orders. Essentially, that means that the agreement between the parents about the parenting arrangements is reduced to writing, signed by both the parents, and submitted to the family court with an application form. If the court is happy with the orders, that is, the terms are in the best interests of the children, the court will approve those orders, and then those orders become binding and enforceable, just as if the court had made them of their own volition. So once made, parents can be punished for failing to comply with orders, and there's a variety of different contravention remedies available to the court, depending on the seriousness of the contravention. It's important to know that if parents do enter into a parenting plan after orders have been made, either by consent or as decided by the court, the terms of the subsequently entered parenting plan override the terms of the order, even though of itself the parenting plan is not legally binding and enforceable. So what is family counselling? It is a process in which a family counsellor helps parties or children with issues relating to marriage, separation or divorce. Importantly, a family counsellor must be authorised in accordance with Section 10 C of the Act. There are 5 categories in Section 10 C, including, for example, complying with accreditation rules, etc. But in practice, there is actually only one of these categories that's capable of being fulfilled, and that is that a person is authorised to act on behalf of an organisation which has been designated by the Minister. There is a list on the Federal Attorney General's website of the designated organisations. and those organisations designated by the Minister to provide family counselling include the well-known ones such as Relationships Australia, Centacare, Uniting Care and Lifeline. So unless you are working for and are authorised by one of those organisations, you don't come within the definition of family counsellor for the purposes of the Act. You may be providing family counselling in the ordinary meaning, but not family counselling as defined in the Act, and not as a family counsellor as defined in the Act. In terms of family dispute resolution process, an FDR practitioner conducts a conference or mediation to assist parties to resolve issues relating to parenting following separation and or divorce. Again, a family dispute resolution practitioner must be accredited under Section 10 G of the Act, and generally that means by complying with accreditation rules, completing the appropriate course, and undertaking supervised sessions with a qualified FDR practitioner, and then becoming accredited themselves. As mentioned moments ago, FDR is mandated by the Act as necessary and compulsory before parents proceed to court regarding parenting arrangements, unless one of the exemptions, such as where there's family violence or urgency. So in terms of court proceedings, the process begins with an application where one party files or submits to the court registry an application asking the court for particular orders. And that application is supported by an affidavit from that party and perhaps from other people, setting out their evidence as to why they seek those orders. The other mandatory document is a notice of risk, which identifies the risk of harm or likely risk of harm to the child. Both the applicant and the respondent need to file this completed notice of risk. The other party is served with the application and should respond within the required time frame. The rules on this time limit have changed recently in the Federal Circuit Court and are now 28 days from the date of service. To respond, the respondent files a response, setting out the orders they seek, and an affidavit with their supporting evidence and notice of risk. The matter then comes before the court for a first court event, usually called a first return date or mention date. And at the first hearing, the court wants to assess what the case is about, assess what further evidence might be required in order to make a decision, and also to make some interim orders about what should happen in relation to the children, pending that further information being made available. In almost all cases, the court will order the preparation of a family report. A family report, as many of you may know, is an assessment prepared by a social worker or psychologist who has experience in dealing with family law parenting matters. And that family report writer will undertake an assessment of the family for the purposes of providing a report in either a long report form or in a shorter memo form to the court. That assessment involves interviewing each of the parents and any other significant adults involved in the child's life, observing the children interacting with the parents and other significant others. And this observation for young children might be an observed play session, and with older children it might be observing interactions of the family when they're all together at the report writer's offices. The report writer will also interview the children depending on their age and how appropriate it is to be questioning the children about their living arrangements. The family report writer will also read all documents that have been produced to the court, so that includes both parties' affidavit material, but also any documents that may have been subpoenaed, which might include things like reports from a counsellor or notes from a counsellor. The court also has power to appoint an independent children's lawyer, or ICL, for the children, and their role is to advocate for the children's best interests rather than what the children want. The ICLs do not take direct instructions from the children, and they're funded by legal aid, so they're separate to the parents. ICLs tend to be appointed in cases that are particularly difficult, such as where there are substance abuse issues, mental health issues, and international relocation matters, or where a parent or both of the parents are not legally represented. Now, the other stages of the process in terms of the court proceedings are the interim hearing and the trial. And it's probably easiest to talk about the trial first, in that that's the end date that all court processes are working towards, which is where all witnesses in the case will give evidence and be cross-examined. The parties or their lawyers will make submissions about the case, and the judge will make a final decision. And that's the only opportunity that the court really has to test the evidence of each of the parents and make a final decision. So by contrast, an interim hearing, which is a hearing somewhere along the way towards a final hearing, and perhaps there's several before you get to a final hearing, Those are hearings where there's no cross-examination or testing of the witnesses. So independent evidence at interim hearings is valuable because often the parents each say something completely different to the other and their stories are completely different in their affidavit. And the court has no way of knowing which of the parents is more credible about the disputed facts. The independent evidence may be that of a family report, a report from a counsellor, or notes that have been produced by a counsellor, and these are quite important at the interim hearing stage in terms of those reports or notes being the only independent expert evidence about what's been going on with this particular family. And so that's the process that the court proceedings go through, and it's very much a process. Currently, less than 10% of cases that actually start in the court process are decided at a final hearing or trial, as most cases do settle along the way, particularly after the family report is being prepared, as it's such an important piece of objective evidence. And whilst the court's not bound by the recommendations of the report writer, they're normally pretty persuasive, and most people will settle a case rather than proceed to a final hearing or trial because of the cost and delay involved in the court process. And one judge of the Federal Circuit Court told us recently that she's not listing non-urgent parenting matters for final hearing in her court until 2020. And we know it's a tactic by Her Honour to encourage parents to resolve their matter by agreement. However, that is a substantial delay. I just wanted to quickly touch on the issue of whether you can be required to give evidence to a court. And the short answer is yes. And the way that is normally done is through a subpoena being issued by a party in the proceedings and served on you. Subpoenas can be issued from any of the courts exercising family law jurisdiction or other courts, such as in domestic violence matters. And a subpoena can either be for you to produce documents or to give oral evidence to the court. Another option is that you might be asked by a parent or by their lawyer to provide a report about the client's attendances with you. If that is to be admitted into the court, then it normally needs to be attached to an affidavit sworn by you to be submitted to the court to be able to be relied upon. In the family court, the rules have been amended very recently and are now slightly different to those in the Federal Circuit Court, in that your report will no longer be annexed to an affidavit to be sworn by you, but will form part of the party's tender bundle to be provided to the judge and the other party at the final hearing. So subpoenas compel you to give evidence. The court has directed you to give that evidence, so you must either produce the documents to the court or attend to give evidence as the subpoena directs. There are penalties if you don't comply, and there are some limited grounds that you can object to the subpoena. For example, the information that's being requested is irrelevant or too broad. You're entitled to be paid conduct money for producing those documents to the court, and you can also ask for costs of having to actually attend court. My suggestion would be that it's prudent to inform your client that you've been subpoenaed and also to seek some legal advice prior to producing those documents. Even though it is likely that if the subpoena has been properly drafted and properly issued to you, that you'll have to produce those documents, it would always be prudent to get some advice about that before just posting everything off to the court. And my understanding is that if you contact your professional indemnity insurer, often they will be able to provide you with or put you in touch with someone who can provide you with some legal advice before producing any of those documents. And it's important to note that your client or patient will likely be aware if you or your material has been subpoenaed, and they'll also have the opportunity to object if they have an issue with the documents being produced. If you're voluntarily producing something, like a report for a client, it may well end up being used in the court process. As I mentioned, a report normally must be attached to an affidavit, which the solicitor would prepare, and that affidavit would say something like, I'm a psychologist registered to practice in Australia. I was asked to prepare a report. A copy of my report is attached and I believe it's true and accurate. And that's for proceedings in the Federal Circuit Court. If you produce an affidavit like that to the court, you should be aware that you could be called to give evidence at trial and be cross-examined about the contents of your report. So let's move away from the federal laws to look at the state-based domestic violence laws and the recent changes to those laws in Queensland. In recent years, the issue of domestic violence has gained greater attention from both the media and in the political sphere. A driving force in increasing awareness and focusing the spotlight on the prevalence of domestic and family violence has been the voice of Rosie Batty, as well as, unfortunately, high-profile domestic violence incidents. In 2015, the Premier ordered an extensive review of domestic and family violence laws in Queensland, and the Not Now, Not Ever report was a result of that review, headed by Dame Quentin Bryce. That report has been the catalyst for major changes to the legislation in Queensland between 2015 and May 2017. The report increased awareness of the many different forms that domestic and family violence can take, not just physical violence, but psychological and emotional abuse. On the slide is the legislative definition of domestic violence, which has been broadened in recent years. The relevant legislation is state-specific legislation. So in Queensland, the relevant act is the Domestic and Family Violence Protection Act 2012, and I'll refer to it as the Protection Act. And the Protection Act has been amended most recently in May last year. Section 8 of the Act defines domestic violence as behaviour towards a person which is physically, sexually, economically, emotionally, or psychologically abusive, coercive, threatening, or controlling. The definition is a very broad definition, but helpfully the Protection Act in sections 8 to 12 provides a non-exhaustive list of behaviours that can fall into that definition of domestic violence. And these include damaging or threatening to damage property, coercing a person to engage in sexual activity, causing or threatening an animal. This has been included as many DV refuges don't allow animals, so often people seeking to leave a relationship are reluctant to without their animal, as there may have been a threat of harm against the animal by the perpetrator of domestic violence. Unauthorised surveillance of a person, and this is becoming an increasing issue given the technology available to us at our fingertips with our smartphones. There are apps which allow people to monitor the geographical location of a phone, and these can be placed on a phone without the other person's knowledge. It is also an issue if the phone is in the name of the other partner, which allows the partner access to tracking data of that handset. Exposing a child to domestic violence, following a person, repeatedly texting and emailing a person, preventing a person from keeping in touch with family and friends, removing or selling a person's property without consent, coercing a person to sign for finance, preventing a person from obtaining employment, which ultimately prevents that person from having financial independence and means they continue to rely on their partner or others for financial needs, and coercing a person to obtain social security benefits. And there are a number of other behaviours provided as examples in the Act, and they can be a really helpful resource as to whether behaviours engaged in are or are not domestic violence. So when a person wishes to apply for a protection order, the form as shown on the slide needs to be completed by the aggrieved, so the person against whom the act of domestic violence has been perpetrated, or the police on the aggrieved's behalf. The form, once complete, is to be filed with any Magistrates Court of Queensland registry. And as mentioned earlier, domestic violence orders are made in accordance with state legislation, which is applied and enforced by the state courts. This form is available on the Magistrates Court of Queensland website, and the specific link is provided on the slide. Local police stations and magistrates courts also have hard copies available of this and other relevant forms. The form has a section which seeks the aggrieved's address details. If, however, the aggrieved does not wish to include their details, they're not required to provide them and can complete a separate form for the court's eyes only. So bear this in mind if any of your clients have safety concerns. Until recently, if a protection order is made on an ongoing basis, the default period of the order was 2 years from the date the order was made. However, recent amendments changed that default period to 5 years, unless the court is satisfied that there are sufficient reasons to make the order for less than 5 years. So that's a significant and important change. Another major recent amendment to domestic violence laws, which has an impact in relation to family law parenting matters, is previously magistrates had a discretion to consider any family orders in place, and they suspend those orders if necessary, particularly where there was a conflict in the operation of the protection order and the parenting order. However, the research revealed that magistrates were reluctant to apply that discretion. Now, magistrates must always consider any existing family law order and consider whether those orders should be amended, suspended, or varied. And that is to resolve any inconsistencies between the protection order and the family law parenting order. However, we're yet to see how each magistrate actually applies this and whether the magistrates are willing to amend the parenting orders if those orders are made prior to the protection order application being considered. The magistrates at the Specialist Domestic and Family Violence Courts at Southport, Beenleigh and Townsville have a very cautious approach to granting orders for any period less than 5 years, even where a respondent and an aggrieved may consent to a period less than 5 years. So, given the diversity of the topics discussed this afternoon, the overriding advice I would encourage you to take away from today is to encourage your clients to seek family law advice and seek the advice early on any of the issues or other family law issues discussed this afternoon. And given we appreciate that legal advice from a private solicitor, bear in mind our initial consultation has a fixed fee, is not always an option for people, I've included on the slide the details for a couple of Brisbane's community legal centres where people can obtain free legal advice in a 20-minute or so session, whether in person or over the phone. And the website address on the screen is the link to a list of community legal centres in Queensland. And we'd also welcome the opportunity to attend at your practice to provide a more in-depth presentation on topics of interest to your staff and clients. So thank you all for your attendance today. An audio recording of this webinar will be made available on our website under the Seminars and Webinars tab. If you didn't download a copy of my slides via the Handout tab and would like a copy, please do not hesitate to contact our office. A feedback survey will pop up shortly regarding this webinar today, and we thank you in advance for taking the time to complete that. And please, if you have any further questions which arise on the topics we've discussed in this webinar, I'm very happy to receive those by email at the email address on the slide at law@mlynch.com.au. So thank you all again for your attendance.